An arrest for driving while intoxicated is understandably stressful. For non-lawyers, the criminal process is complicated and uncertain. Today, I hope to alleviate some of that stress by walking through what happens after a DWI arrest in New York. Post-arrest. DWI cases begin with an arrest. The accused driver is transported to the police station, where they are booked into the system, given a blood alcohol test, and placed in a holding cell until they're no longer impaired. Release from police custody can happen with or without bail. If released, the driver will leave with an appearance ticket telling them their first court date. Alternatively, the driver might remain in custody until their first court date. Arraignment. The first court date is known as the arraignment. At the arraignment, the judge tells the driver what they're being accused of, informs them of their right to be represented by an attorney, and asks them to plead guilty or not guilty. The judge might also set or adjust bail and will suspend the accused person's driver's license pending a separate hearing at the Department of Motor Vehicles. If the driver pleads guilty, the judge will set a sentencing hearing. If the driver pleads not guilty, the next step is a pretrial conference. The pretrial conference. At a pretrial conference, the attorneys for each side, meaning the defense attorney and the prosecutor, can discuss the possibility of a plea bargain. A plea bargain is when someone accused of a crime or other offense agrees to plead guilty to a less severe offense than which they're facing in exchange for a lighter sentence. Now, one doesn't have to accept a plea bargain. However, people often do so when the state's case is strong, because it sometimes makes more sense to accept a lighter sentence than to risk the more severe penalties at trial. Pre-trial hearings. Next are pre-trial hearings, which are used to resolve certain issues before trial. An important pre-trial hearing is a suppression hearing. At a suppression hearing, the defense attorney asks the court to not allow certain types of evidence to be presented at trial on the basis that they were obtained unlawfully. A suppression hearing can even be used to have a case dismissed under the appropriate circumstances. Trial. The next step is trial. At trial, both the state and the defense present their cases, and the accused driver is either found guilty or not guilty. It's the state's responsibility at trial to prove the accused person guilty beyond a reasonable doubt. This means the judge or jury will have to be virtually certain that the accused person is guilty in order to convict them. If the judge or jury finds the accused driver not guilty, the charges are dismissed and the case ends there. If the accused driver is found guilty, pleads guilty in the beginning, or accepts a plea bargain, there will usually be a sentencing hearing. Sentencing. At the sentencing hearing, the defense can argue for less harsh penalties. The court then orders whatever penalties it sees fit. As you can see, the process after a DWI arrest can be long and complicated. At each step, attorneys provide vital support that can mean the difference between jail time and walking free. At Rosenblum Law, we have decades of experience expertly helping drivers achieve the very best outcomes in their DWI cases. If you or a loved one has been charged with a DWI offense, contact us at Rosenblum Law today for a free, no-obligation consultation. We'll review the facts of your case, answer any questions you may have, and provide the best possible strategy to get you the best outcome under the circumstances.